Hello and welcome everyone to the Wall Street Blockchain Alliance's Crypto Roundup for Friday, February 9th, 2024. Ron Quaranta here with my amazing co-hosts David Brill and Josh Klayman and our very special guest, the one, the only, Sam Enzer. Sam, thank you for joining us. Before we begin, for everyone in the audience on LinkedIn and Twitter and I believe Facebook now, thank you for joining us. If you've got questions for anyone in the panel or on the group, please put them in the chat. We'll answer them as best as we can. Please also keep in mind that nothing discussed should be considered accounting, investment, legal, or tax advice. Today's episode is brought to you by WSBA member firm Technos Associates. Technos, the digital asset valuation specialists, great team. Shout out to Casper. Find out more at technosassociates.com. That's TEKNOS associates.com. So much to cover, David and Josh. And Sam, welcome to the episode.
Thanks for having me. Pleasure to be here.
David, before you and I launch into some of the conversation about the market stuff, and I get, for the audience, I get regular text messages from David about market moves, which is always a fascinating read. But I wanted to kick off with some of the stuff that we've seen most recently, and it's my favorite bugaboo right now is I'm going to bring up the debt box case. Josh, you and I mentioned it, and Sam, I wanted to pull you and David into this. One of the things we've seen from the industry is the pushback that, oh, look, see, the SEC is operating in a corrupt manner. It's always a bit more nuanced than that. I want to lay out the facts for the audience. Josh, do you want to start us off? What happened with that case? We talked about it at the legal working group. Let's talk to the audience.
So just at a very high level with where we are now, although I'm not as close to the actual facts as certainly others are, is that, the debt box side moved for sanctions, right, against the SEC, and the SEC is fired back really on its back heels, right? We're not used to seeing the SEC in this position saying, hey, we shouldn't be subject to sanctions because that would be too harsh. Actually, we're doing all these internal trainings and other activities to make sure that, this stuff never happens again. Basically, the idea that there were material misstatements that were made in connection with getting a TRO, right, with getting emergency relief that had the effect of really crippling debt box.
Josh, thanks. Sam, can I pull you into this? And David, please chime in as well. I'm going to ask the layman's question as the only non-attorney on this entire broadcast. How badly does a regulatory attorney need to mess up for the court to say, you really messed up, there might be sanctions here? Like, what does that look like?
It's a good question. And, there's sort of two sides to that coin. I used to be a federal prosecutor in the Southern District of New York, and there were cases where prosecutors made missteps, failing to disclose exculpatory information, making statements that turned out to be inaccurate. And there have been consequences in some of those cases. For example, and to be clear, not in my cases, but other folks. I remember a case called Solder, United States versus Solder, where the government was accused of not turning over exculpatory information. And in the end, the judge admonished the prosecutors, demanded that the government engage in trainings of its people, dismissed the indictment and shamed the office. Shame the office. That's an example of it. I would say it's rare for government attorneys to be sanctioned or rebuked. So it's not something that happens that much, and it's got to be pretty extreme. Here, what's going on is, the SEC has formidable power, right? I think many people think of the SEC and dismiss it as, oh, it's just fines. But when you think about what they can do, if they seek emergency relief, what they are doing is going to a judge and saying, hey, we want a court order shutting down a business, freezing their accounts, making it so that they can't pay payroll, or taking other very extreme actions. And when they do that on an expedited basis, you're really on your back foot if you're defending the case.
Yeah.
You may not have much warning. The whole point of an emergency action is that this isn't done in the normal process. So they come into court, they have been secretly working on papers. They may come in with 300 pages, 1,000 pages of briefing, affidavits, evidence, allegations supporting their assertion that this extraordinary relief is required. And then, all of a sudden, within hours, you have to respond in front of a judge as to whether or not something immediate should happen. It's very difficult to respond to. And so it's very important, if the government is going to be given that power, if we are going to trust them to have that power, then it is incumbent on them that there must be diligence. We must be able to trust that they're only going to do it when it's appropriate, that what they say is 100% accurate. And that's not what happened in DebtBox. In DebtBox, misstatements were made. I don't know whether they were intentional or sloppy, but regardless, right? If I am a police officer and I sloppily shoot and kill somebody, there should be consequences. Well, the SEC equivalent of that is emergency relief that cripples a business. What should the consequences be? The consequences should be severe. Otherwise, you're not going to deter the conduct.
Right. Sam, thanks so much.
I have a question about that. Is
Go
it
for
okay
it.
if I ask?
Yeah, go for it.
In looking at the filing the SEC made most recently, they basically say, look, this shouldn't, I guess defendants were arguing that there should be dismissal with prejudice, right? So it could never be brought again. And the SEC says, no, that's going too far. And the defendants ask for, payments, right, for losses and other fees. And the SEC says that's going too far, and also says, well, sovereign immunity and things like that. And here they're saying that dismissing without prejudice and these internal trainings, that should be enough. But I'm just curious, is there, I guess no one can really know, but I'm just curious for your views, guys. Do you think if it's dismissed without prejudice, is there a likelihood that after all this, it would be brought again? And I guess my related and separate question is, if it's dismissed without prejudice and there are no fines and they can bring it again, is there really a punishment? So, yeah,
Yeah, I wonder why, as part of the agreement, they didn't push for a dismissal with prejudice. I mean, I guess the benefit is that
pushing for that.
Yeah,
SEC should exist. Sorry.
I mean, I think where I have an issue is the kind of effect a TRO has on an individual or on a company is so dramatic that if we can't, if a judge or an entity has to fight a regulator and fight allegations that may not be legitimate and can be backed up. I mean, Sam, you can talk about the standard for getting a TRO, but the standard really is it's reliance on the facts as presented by the regulator. And so if you're undermining the reliance of those facts, it really undermines the legitimacy of trying to get TROs.
Yeah, the standard to get a temporary restraining order or injunctive relief is, one, a showing that you are likely to succeed on the merits of your claims, and two, showing that there will be irreparable injury to the moving party if immediate relief is not given. In other words, relief, if you could be made whole with money damages, that's not a situation where an injunction is appropriate. But if something is going to happen that cannot be undone, that does harm, that's where you have irreparable injury and need an injunction. And then the balance of the equities, if you look at the prejudice, the costs or the benefits of an injunction, do they weigh in favor of imposing the injunction? If you look at who is harmed and who is not. And all of that depends on, do we trust the allegations of the moving party, right? This is all premised on being able to credit the allegations of the regulator coming in and saying, do this extraordinary thing. It's silly to say without prejudice, because I can't conceive of a world where the SEC comes back to court and says, we lied before and we're shamed, but we'd like to reopen this case. You know, what the one thing that you could imagine is Debtbox, if they were to go do something new that was illegal.
Right.
You know, the SEC, the government can't be hamstrung from going after them for that just because of a screw up in case number one, right? And I will say, like, look, for the government folks out there, there is no question that whether a fine is imposed or not, this is very embarrassing. It's very embarrassing to the agency. It's very embarrassing to the attorneys involved. I'm sure they feel terrible, and that will chasten them. And I think also, I imagine everyone else who didn't work on the case doesn't want to be the next Debtbox. You know, these are real people. They're people with careers. Moreover, you know, it's going to hurt the SEC's credibility in other cases. This is going to get cited over and over and over again. I'll just say, though, you know, I think the SEC, it is not uncommon for them to be less than careful in representations they make. And I think that's in part because, you know, I was a prosecutor in the Department of Justice. As a criminal prosecutor, you have to prove your case beyond a reasonable doubt. You don't bring a case unless you're prepared to try it, right? And so that has a disciplining effect on making sure that what you say is right. You know, I may have to prove this in court. I may have to prove it beyond a reasonable doubt. It may be subject to cross-examination, defense argument, scrutiny from a jury, scrutiny from a judge. Let's be careful about not getting ahead of our skis. The SEC is set up very differently. So first of all, many people don't know this. The SEC has staff attorneys who investigate a case, who do not then work on the litigation. Okay, so they do not see what happens, how it plays out in court, if they make an allegation that isn't adequately supported. Right? This creates, and I'm not talking about particular people, but if you just think about like game theory, economic incentives, and the way that rational actors operate, your incentive is, let me investigate and make an allegation and charge the case. I have then succeeded. It is off my plate. And now it is the problem of a trial attorney to litigate or resolve the case. And it's not my fault or problem if they can't prove the allegations or if there's an issue there. Or you simply don't get the experience of getting punched in the face when you make an allegation that is weak and there are 20 responses to it, and you just don't know what it's like to get punched back. You know what I mean? As Mike Tyson says, everybody has a plan until you get punched in the face.
Sam, it's so true. Thanks for that, David. I want to pull you into one of my more provocative comments that I often make when we have these conversations. And you know, Sam, really appreciate the job and context around Debtbox, for example. David, you know, one of my mentors told me a long time ago, culture at an organization comes from the top, right? And when we look at things like Debtbox, when we look at, you know, Congress pushing back on SAB 121, we look at some of the ways the SEC seems to have been put on its back foot a little bit. And again, this is not to pick on the SEC. Is this culture from the top, this kind of fast and loose a bit, part of what's damaging the SEC's activities here, David?
So you want me to say the quiet part out loud? So
I queued that up for you, my friend.
Look, what I'll say is that it feels like the commission's view towards digital assets is one of enforcement and one of focusing on the challenges of the of the crypto ecosystem and less of focus on the regulatory part of it. And I think you can just go by the thesis that there's a prevailing view that the current rules under the 33 and 34 Act can still apply to crypto and still regulate this ecosystem. And I think people and practitioners like myself and Josh and Sam and others believe that there are gaps because of the way the technology works, the fact that an underlying token itself is not a security, but it's how you transact with that token that may or may not make it a security. that really creates these difficult issues that we face. And so if you have more of a view that these are bad actors and less of a view that we need to evolve our system, our regulations to reflect this new technology, it creates a dynamic more focused on regulation. Sorry, more focused on enforcement than regulation.
David, thanks. Josh, Sam, go for it. Yeah, I was just going to ask.
Well, so, I mean, it's funny, Ron, you said SEC playing fast and loose. I mean, thinking from a slightly different perspective, I mean, I don't know that I would say necessarily that means they're playing fast and loose. It could be actually that there's a lot of pressure from the top to not let anything slip out of your hands, right? And rather than being, I mean, the effect may be that mistakes are made because of, I don't know, aggressive pursuit. But I think, to my mind, like, it goes back to this idea of not on my watch, right? Paired with a skepticism. And so to me, that's slightly different. I would imagine that, at least the SEC staff that I know, I don't imagine them playing fast and loose, right? But I could imagine a lot of pressure from the top to get things.
Josh,
Yeah, look, I think it's worth saying that I probably should have said this earlier, but I think it's worth saying that, look, by and large, I think people who work for the government, they're doing a public service. And by and large, especially at the staff level, I'd like to believe that most people are acting in good faith. And mistakes happen. We're all human, right? And so I don't think this is so much about what specific individuals did. It's more about thinking about how our institutions are doing it, right? And there is a problem here of a very aggressive chair, a chair who's not a lawyer, a chair who is on sort of a jihad against crypto. That now, look, if you're defending, where does it come from? It really wasn't helpful to have FTX and a bunch of other situations in 2022. And that puts a lot of pressure on the agency, and maybe makes them, overreact. And I do think there was an overreaction. I do think that that just as a lot of the people at the SEC are acting in good faith, the majority of the people in the industry are acting in good faith. And, don't throw the baby out with the bathwater, right?
Yeah.
But where we are now is, the chair, Mr. Gensler, was very aggressive against crypto even before those situations. It escalated in the wake of FTX and the other high-profile collapses that occurred in 2022. There seems to be anecdotal reports of a lot of pressure from upper management for the staff attorneys to bring cases, to bring them swiftly. And that's a recipe for disaster. It's a recipe for mistakes.
Yep. And Sam, thanks for that. And Josh, to chime in real quickly, and for anyone at the SEC who might be watching, I am not saying you're playing fast and loose. I'm just trying to comment on what some of the crypto industry might be perceiving it as. And, in deference to the SEC, they have obviously got a mission and staff. Sam, we've, for the folks that are staffers there, we know they do the hard work. But, the other thing that I want to raise here for the group, SEC is not the only game in town when it comes to understanding the landscape in the United States for crypto and digital assets. So I want to bring up, recently we had the Fed chair, Janet Yellen, testifying at Capitol Hill, particularly on their strategy around stablecoins and their concerns. David, you and I have had this conversation about, well, now is it systemically risky? And I remember the conversations you and I had 5, 6, 7 years ago when it was crypto's a little p, we don't care. Now it's, wait, there might be national security risks. Wait, there might be systemic financial risks. What did you take out of the commentary from Chair Yellen this week?
Well, it's really interesting because if you look at some of the recent cases, the SEC is making the point that, the major questions doctrine doesn't apply because crypto is such a small part of the financial services ecosystem. And then you have Janet Yellen come out and talk about, the potential risks of stablecoins. I mean, it's fascinating. Sam hit on something before that we've talked about, and I talked about specifically about, Chair Gensler not being a lawyer. And I think sometimes there's just frustrations that the law isn't being able to be used in a way to bring the desires of the commission forward, or maybe his desires forward. And so, I think, again, there's been a real underestimation of the really top-notch lawyers that are part of this crypto bar or defending some of the crypto companies. And really kudos to them. They have brought really the A players to come and fight for these companies, and we're seeing results from that. Pivoting to your question, look, I think the issue becomes more of a national security issue, in that if stablecoins and if that ecosystem grows to a point where the ability to use sanctions on foreign countries to access the US markets and the US banking system is lessened, then that's a problem. Because part of our financial superiority is sanctioning countries that we believe are not acting appropriately or acting as a good member in the group of nations. And if it's lessened because of crypto and stablecoins, that's a national security issue. And I think, I don't want to say what the chair was thinking, but that's always been what my thought process was behind the scenes and why it's important to the government.
Yeah, I'll just say here on this, two things. Before I forget, I think it's important for us to put the disclaimers out there. None of this is investment advice. None of it's legal advice.
Yep.
The opinions expressed are those of the speakers and not of the organizations they work for. I personally am only offering opinions on behalf of Ron Quaranta here.
Oh, dear Lord.
But on the so send your lawsuits to Ron, and he'll be dealing with those.
We're going to get canceled by the board. Go ahead. Please continue.
On the Treasury issue, I think what you're seeing is a stable coin, at least, what is a stable coin, right? It is a digital asset backed by the dollar, a fiat. Now, if you have, which is really tokenized dollars. Now, if you have tokenized dollars that do not get issued by the United States government, that could present an existential threat to the government's stronghold over monetary policy, right? The way that they influence the economy, the way they use monetary policy is largely through the issuance of dollars, et cetera. Now, one could argue they're interrelated, but I think what you're seeing is the government is nervous. Treasury Secretary Yellen is nervous about what does a stable coin mean. This relates to also about discussions of CBDC. How would that play out? And by the way, I think that what Yellen is proposing is not to ban stable coins, but rather I believe that where she stands on it is she wants only banks to be the only banks which are supervised by the Fed to be the ones to issue them, right? So that's a way sort of bringing it back under the control of centralized monetary policy.
I want to personally thank Sam with, I know, some members of the board watching, endangering my job now, and I'll have to just come work for you. But Josh, please chime in here. And I want to throw one wrinkle at this, Josh, and I know you and David talk about this a lot. We've got the regulators. We talked about Fed Chair Yellen. It also is an election year. How much of this is also politics?
So maybe I'll answer that first and then loop back.
Sure.
I think a lot of it is politics. I think a lot of it is because despite all of the statements, we'll see whether and which laws, if any, can get passed in this area, right? And I do think a lot of this is political. A lot of this ties in, as David said, to national security, right? That's the newest thing. But these are not new words. Like when Brian Brooks was at the OCC, right? His view, I'm paraphrasing, I think his view, was that, issuers of stablecoins should be able to become banks. And then after he left, the prevailing view was what Sam just said about Janet Yellen, the idea that only banks should be able to issue stablecoins. And we've been hearing some of the same things that Janet Yellen said since 2012 21 from Michael Hsu, the acting head of the OCC, who's been coming down repeatedly on stablecoins, including especially Tether, right? When he was talking beginning in 2021, talking about commercial paper and how much commercial paper was backing Tether, right? And that it's relatively illiquid, and warning about the possibility of a financial crisis, right? Not just a parallel financial crisis, but actually a bigger financial crisis again, and drawing parallels to the last financial crisis. So I do think it's interesting that literally some of the same sound bites are coming out now from Janet Yellen when we have heard these things. And that's why many people have been saying for a while this Operation Choke Point, in part, to keep things separate. But I do think the election year and the geopolitical instability that we've been seeing, East, West, global North, global South, like anywhere you slice and dice it. And I think that that's why these things are coming up more and more. But I do think sort of like, and the beat goes on.
Yeah.
But we'll see where it comes.
And in fairness, some of the original concerns about stablecoins are still there. We couldn't even verify the reserves around some of the stablecoin tokens. So it's a really important topic, Josh. Thank you, Sam. And David, I want to move over to you if we could. I know you've got to hop soon. In the backdrop of all of this, we've got Bitcoin ETFs cracking 2 billion. We've got institutional flows still coming in. My wife wants to know why I'm not a Bitcoin billionaire. But David, what's going on with the markets?
Well, the markets it's a really fascinating time right now. So first of all, 2 of the Bitcoin ETFs have been, after 1 month, the top performing ETFs with assets under management. So it just gives you a flavor for, of all the ETFs that have come out in the first month, 2 of the Bitcoin ETFs are the highest performing ones for assets under management. So I think that gives you a sense of the interest that people have in the Bitcoin ETFs. And I think it's also really important to know that a lot of people still don't have access to the Bitcoin ETFs through some of their platforms, whether it be Vanguard, whether it be, I think LPL, I saw made an announcement about that. They're all kind of waiting and seeing. So there's really another corner of the market that can't get access to them from their traditional distribution channels. So I think we're in a really interesting place. I think it's clear that there's demand, but there are also some supply overhangs. Genesis is looking to sell about around $1 billion, $1.5 billion of GBTC to pay creditors in their bankruptcy. And with FTX and Celsius creditors starting to get their funds, we could see some selling pressure from individuals who just now getting access to their assets, wanting to sell some of their assets, maybe needing the liquidity. But we're right now at like 47,500, and we're almost at sort of the high point, 48,000 for the year and then for a period of time. So I would really pay attention to that number, because if we do push through meaningfully 48, I think we can go to like 52,000. Now, my prevailing view, though, just to share, is that I felt like we have a sell-off incoming, and I still have not walked away from that notion, and that I feel like there will be one more sort of retest into the 30s. But this development's been really interesting, and I'm going to be following it most of the weekend.
David, I know you've got to hop. I think you're lending in either Monte Carlo or Vail. I keep forgetting. But one of the analyst comments that came out this morning, with the halving coming up, put out a price target of 170,000 per Bitcoin. And again, we don't offer investment advice, but that feels a little high to me.
It feels overly optimistic. I could see us by the end of the year having a new high in Bitcoin and Ethereum, especially if we got an Ethereum ETF. But I think 170,000 is very optimistic.
David, appreciate it. Go ahead, Josh.
We have like 1 minute with David left, right?
Yes, so, go for it.
Question. What effect, if any, do you think these emergency requests for information on miners could have?
In the short term, I don't think they'll have much. In the longer term, if it looks like there's legislation, or it looks like there's sort of punitive action coming against miners, I think that could have an effect. But this is the kind of business, I think it's a little bit short-sighted, in the sense that if it's not going to happen here, it's going to happen somewhere else. So it might be better to have it here and at least the U.S. profit from it. and like have jobs from it than sending it offshore. So it's another crypto project or slice of the crypto ecosystem that's offshore, enriching other countries instead of our own.
David, we appreciate it, buddy. We will see you next week. Enjoy the flight.
Thanks.
We will chat with you again soon.
I'll be coming from Arizona next week, so I'll be looking forward to it.
So now I know I'm going to have a Twitter channel just to track David's jet. Like they do for Elon.
Supposedly somebody's been following me on
Santa
Twitter.
Claus.
Yeah,
Is
we're
it
all
a
the travelers.
G4 or a G5?
Well, I'm going to stay modest here, Sam, so we won't talk about that. But anyway, it's been great, Sam. Thanks so much for being a part of this. Sam and I are friends as well as colleagues, so I really enjoy that you're being here. And I can't wait to listen to the rest of this, so thanks very much.
David, thanks for being here. Good seeing you. Sam, Josh, I want to pull us back into a conversation. One of the interesting conversations we always have is, and again, we talk to folks in the crypto markets that are, Sam, to your point, the builders trying to build. And certainly we know colleagues from the regulatory side or the regulated entity side who look at this and say, we need some oversight here. I think one of the things that the industry's looked at has been the judicial side of it. And for many cases now over the past several months, it's almost been this sense of, well, look at what the judges are saying. You know, they're beating up on Gensler and the SEC. They're pushing back on some regulators. But I want to be clear for the audience, judges take their roles very, very seriously. And it's important to realize how judges come to these decisions. And one of the things I'm referencing specifically, the Ripple case. So everyone in the crypto industry has had this whole sense of Ripple's going to win, et cetera, et cetera. And recently a judge told Ripple they must share financial information with the SEC. I know a lot of colleagues aren't keeping up on the case very much, Sam, but what are your thoughts about how judges are approaching this ecosystem, and where do you see that going in the future?
Sure. So we'll take that. There's sort of two parts to that. One part is the general, what are judges doing? And then the other part is the Ripple case.
Yep.
So on the general, what are judges doing? I think you've seen an evolution. So in the first sort of wave of crypto precedents comes from the period around 2018 and a few years after that, when you had this craze of initial coin offerings, crypto projects raising capital in what looks a lot like an IPO. It looks a lot like a stock offering. I give you stock, you give me money, I use the money to build a startup. So that fit very neatly into what judges would see as a securities transaction. There were a lot of abuses. There were many projects that were just brazen frauds. When I was a prosecutor, I prosecuted the founders of a project called Centratech. They committed a brazen fraud. It's currently featured in a Netflix documentary called Bitconned. You can watch it, but they lied. I mean, they just straight up lied. And fraud is fraud, whether it's on Wall Street, Main Street, or the blockchain. And so you had these cases where judges, what they were really grappling with was lies to get investors to part with money. It happened to be against the backdrop of crypto rather than some other scheme. And so they didn't have to engage, I think, at a complex level with some of the difficult questions about whether the securities laws map onto digital asset trading and markets, whether the Howey test is the right test, whether that applies to secondary market transactions, whether it applies to decentralized finance, some of the deeper questions. Now, the SEC, has decided that if you think of the wave of precedents from the ICO cases as like the basement or the foundation, they're trying to build another layer, layer 2 for crypto terms.
No pun intended.
They're going to layer 2. Or in particular, the Gensler chair administration really is aggressively attacking the infrastructure, the picks and shovels of the crypto economy, digital asset trading platforms that are on-ramps to the crypto highway, stable coins that are the sort of base currency used to trade into and out of digital assets. And This raises real questions about whether the SEC is overreached, whether they're ahead of their skis, whether they have the power to do it, whether the statute fits. And judges are I think, really questioning whether there is a coherent legal theory to support the SEC's very aggressive stance on the reach of the securities laws. They're pushing back, right? The Ripple decision at summary judgment, Judge Torres, I think if that was a Supreme Court case, you would say that the SEC's power has been significantly undercut. It's not a Supreme Court case. It's a trial court.
Yeah.
What does that mean? Other trial judges are not bound by it. Two judges at the trial level can disagree with each other, and we've seen that. Yeah. Judge Rakoff in Terraform has disagreed with Judge Torres in Ripple. And so this is working its way through the courts. There's probably going to be appeals. We're going to need to see what the intermediate circuit courts of appeal say, and then possibly the Supreme Court to settle the issue, right? And that could take time. But in the Coinbase case, SEC versus Coinbase, Judge Fela asked a lot of questions, good questions, about whether the SEC really has a leg to stand on in saying that secondary market transactions are investment contracts under the Howey test, when the exchange has no investment contract, no contract at all with the parties, and certainly no relationship to the initial issuer that issued the tokens. So that's like, at a high level, I think you're seeing that as the SEC pushes the boundaries to layer 2, layer 3, and beyond,
yep,
they're experiencing resistance from the courts because their argument is weaker.
Yep.
And I think you'll see some precedent chip away at that. Now, on the Ripple case, the specific ruling you referenced,
yep,
I don't think this is that big a deal. And I think it's getting way more attention than it really should. You have to remember Judge Torres's ruling, okay? It was a split ruling. She said that certain allegations about certain transactions being securities transactions were incorrect and dismissed them. So, for example, what the SEC had referred to as programmatic sales in blind bid-ask transactions, where Ripple Labs was giving XRP to market makers. Market makers were going onto digital asset trading platforms, selling that in blind bid-ask transactions, and then retail investors were buying it. Those retail investors didn't know who was selling it to them. And I think the judge, I'm not sure I agree with the reason or the way she got there, but I think she was sort of groping with the idea that, look, how can you have an investment contract between a buyer who doesn't even know who they're getting it from, right? Let alone a communication between them and an agreement that somebody's going to do something to create a profit for them without their own efforts, but rather with managerial efforts. And there's no relationship at all. They don't even know who they're buying it from, let alone that they're buying it from the issuer Ripple. But on the other hand, there were certain transactions, certain XRP sales by Ripple that the judge found were unregistered securities transactions illegal. Okay. So, for example, there were sales of XRP to institutions under written agreements. The judge said those are securities transactions. Now, that means the judge has found at summary judgment that there were at least some instances where Ripple violated the securities laws, and there has to be a determination of the penalty. So what the SEC did here is they wanted discovery about a category of sales that the judge has determined were violative that occurred after the filing of the complaint. They want financial discovery so that they can determine whether the evidence would support a penalty for that. Doesn't mean she's going to impose a penalty.
Yep.
It's a question of, is this reasonably calculated to lead to potentially discoverable evidence, admissible evidence? If so, let's share the information in discovery, and then the parties will make their arguments about it. That's all this means.
Yeah. Sam, thanks so much. And I really appreciate that background. I know the audience does as well. Shameless plug for the WSBA. We did our listen party SECV Coinbase, and Sam, we were really privileged to have you kind of narrate and comment through the proceedings. Josh, one of the things I want to pull you into this that we had a conversation about post that event, which is we have available on YouTube, is when we talked about Judge Fela's commentary. And I know over the years, you and I have seen this, Sam mentioned evolution, where there were judges looking at things like crypto 8-9 years ago thinking, what is this pet rock? Now Judge Fela is asking detailed questions about things like decentralized finance or DAOs, for example. Is that evolution going to continue?
I mean, I hope so. Certainly it would. For a long time, it seemed like the enforcement actions that were coming were just the same case over and over and over again. And we still are seeing it about the initial issuance, right? And like it or not, we've moved into a new era where now it is, as Sam and others were saying, focused on other things like market structure, the secondary questions, the second layer, layer two, like Sam was saying. So yeah, I mean, I certainly hope that just as just as we as lawyers have a duty of confidence to our clients, certainly I would imagine that and Judge Fela seems like a brilliant judge who's very focused on the facts and probing. I think the fact that she's asking those questions is wonderful. And frankly, some of the things that she mentioned during that the listening session, which thank you, Sam, as well,
Thank you.
was she was the SEC. Someone from the SEC had brought up staking and the risks associated with staking. And of course, there are macro risks like cyber risks and things like that. But when it came to things like slashing, Judge Fela, if my memory serves me correctly, said something like, but isn't slashing like a low risk, right? And it could be because it was being backstopped, right, by the trading platform in question. But, that's sort of a very quick, following right along. And also some of the questions, like the question about, where is the upper limit? Before this session, we were talking about the upper limits of certain things. And really, where is the upper limit? At what point does any kind of collectible run the risk of tripping the Howey test, right? If it's so applied, and how do you find that limiter? And I think these are the types of questions that we want our judges to be asking.
Yeah, she mentioned limiting principle quite a bit, which was really astounding. And for those of us listening, I think some of us are still trying to recover from an SEC attorney saying Bitcoin's not a security because it has no ecosystem. Part of my head exploded when I heard that, and I suspect Judge Fela might have been a little leery of that as well. Guys, it's really great to have you both. We're just running about out of time. Sam, one of the things we often do at the end of these broadcasts is, I know how busy you both are, is ask for predictions in the coming week, or what are you going to be keeping your eye out in the coming week or two? Besides work.
Let's see. I think we're getting to the point where we could get a decision in the Coinbase or Binance cases on the motions to dismiss. I do expect decisions to happen in the first quarter. I don't know if it would be in the next week, but I'm definitely primed to see what happens there. They've both been fully briefed. Oral argument has happened. The judges were very keyed into the facts, meaning they probably drafted opinions before the oral arguments. So, we could get decisions on those any days. And I think those will be huge, transformative, very illuminating for the industry, right? In terms of where does the law go? I think also, SEC versus Kraken is not as far along, but it raises some of the same issues. I'd like to see what happens in that case.
Sam, thanks so much. Josh, what is your next week looking like, or what are your predictions?
So in terms of predictions, I don't know that I have.
She will never predict a price, by the way, Sam, ever, no matter how many times you try.
To the moon. To the moon.
I mean, but I will say, some of the things that David has been saying about the market and that you guys have all been discussing, I am curious just to see. It seems like David's crystal ball has been pretty good lately. So, seeing what's coming next and just staying tuned to the crypto legal news is really all I have planned for next
I will say, I think if there was any area where you couldn't predict, it's crypto. And if there's any area that requires you to stay glued to your screen to see what's next, it's crypto.
Yeah. Sam, Josh, thank you both for joining
What
us.
are you up to? You didn't say
Me,
you're
I'm going to be building out the website that tracks David's Gulfstream 5 because I have a theory that if he lands in like Monte Carlo or Vail, we can see a price swing up. But I'm trying to figure that algorithm out, and I'll probably do that over a nice glass of Sauvignon Blanc. I'm going to leave it there. Sam, always a privilege. Great to see you. Josh, as always, my friend, great to have you part of it all. For everyone who watched, thank you so much. We'll have this up on our YouTube channel next week. Have a great weekend, everyone.
Thank you. Thanks for having me.
Bye-bye.